We have a lot to talk about, as always, with this new reform. And if you've heard me speak before, some of this may be familiar to you, but I would say that with how fast everything's evolving, there's new information out all the time. It's a really great time to be looking at all of these things and hopefully give everyone some time in preparation for 1 November, because there's a lot to be done, as you all know. So I'm going to start by talking through give you a bit of an overview of the conditions of registrations, and so you can understand as a CHSP provider which of those conditions apply to you and which you don't really need to worry about. When the Act was first introduced, the Commission talked about a sort of proportionate approach to regulation, and how we see that reflected in the Act is that some of the conditions only apply to providers at that higher level of registration, so your levels 5 and 6, which means that those of you registered in the lower levels, particularly levels 2 or below, won't need to worry about compliance with some of the conditions. But as you'll probably see through today, most of the conditions do apply to all providers, perhaps more than we might have expected. So I'll talk also about responsible persons suitability assessments, because again, this is something that's quite new to CHSP providers who haven't necessarily had to grapple with the concept of key personnel before. And so that will be something that CHSP providers will need to start doing as we move forward. I'll touch briefly on worker screening as well, then talk about the code of conduct, service agreements, duty of care and consumer choice, and that will sort of come up through various topics today. I'm going to be talking about complaints, feedback and whistleblowers, incident management and SIRS, security of tenure, or what is called cessation of services or continuity of services under the new Act. I'll talk about the new obligations in terms of privacy and record keeping, and also if I can, I'll talk a bit about associated providers, because although it's not technically a condition of registration as such, it is quite relevant in terms of how you comply with all those conditions of registration. So, status of the reforms, just a quick recap. The Act is commencing in November. We have most of the draft rules, but nothing in final yet. The thing about that is most of the conditions, and certainly all the detail of the conditions, are contained in those rules. So everything I'm telling you today could possibly change when we see the next version or draft of those rules, or perhaps the final version of those rules. So as much as we're giving you information as much as we can about what's coming in November, just bear in mind that some of it may still change. So conditions, let's have a look at these. So obviously these next two slides are going to sort of deal with all of the conditions in the Act, but just to give you an idea, as I said, most of the conditions in the Act or requirements of providers in the Act do apply to most providers, and some apply to all. So we can see the requirements in terms of the statement of rights and the statement of principles. Those they will apply to all providers. The aged care code of conduct applies to everyone. The aged care quality standards, on the other hand, they're only going to capture you if you're registered in level 4 and above. Continuous improvement, that applies across the board. Requirement to have a care plan with clients, that will apply across the board. Requirement to have a service agreement, a big topic of discussion and certainly a focus for us at the moment. Again, that applies to all providers. So even those of you who may only be registered for, say, Meals on Wheels or that sort of a service, it will still apply to you. Compliance with financial and prudential standards, that will apply if you are registered in level 4 and above, and I'll talk through what that looks like. The aged care worker screening and qualifications, that again applies to all providers, and there are some unique things about that when it comes to CHSP. The responsible person screening, that applies to all. These next two conditions you do not need to worry about unless you're in residential care, so that's around restrictive practices. Although restrictive practices does apply to an extent in community care, and that again will include everyone because of the way the CERS regime works. So I'll talk a little bit about CERS today too. Bless, excuse me. Okay, so governing bodies. So this will be another requirement I'll talk in some depth about, because again, this is a bit new to CHSP. But if you're registered in level 4 or below, you don't need to worry about governing bodies. Supporters, again, that's going to apply to everyone. Complaints, whistleblowers, incident management, that will apply to everyone from level 2 up. And CERS will apply to everyone across the board. So as you can see, there are some providers that won't need to comply with as much, but most of the conditions will apply to most of you. Governance. Okay, so we'll dive into governance. And just to recap again, this is only for those of you registered in level 5 and above. So what this slide does is sort of summarise all the reforms when it comes to governance that we've seen over the last few years, which are then captured by the new Act. So if you're currently in residential or home care, a lot of these will not be new to you, but in CHSP, of course, there may be some new things here. So we've seen new rules in terms of who sits on your governing body, or rather your board. We've also seen the requirement to have advisory bodies, and that's a quality care advisory body, as well as a consumer advisory body. With the consumer advisory body, you don't necessarily need to have one, but you do need to give consumers the opportunity to establish a consumer advisory body and then feed that information up to the board, who then acts on it. Boards also have to do a statement of compliance, as well as a report on the provider operations, where they effectively say, how did the provider go in terms of its compliance with the Aged Care Act over the last financial year? So that came in a couple of years ago, and it was really in response to the Royal Commission's concerns that boards were not turning their attention to the quality of care enough. So all of these reforms were very much designed to improve the governance of aged care providers, more specifically than what we see through other regimes like the Corporations Law and ACNC requirements. There are also requirements in terms of what providers put in their constitutions. I'm not going to go into those, but if you're a subsidiary, there's certain things that you can't say in your constitution that you might have otherwise. And the code of conduct, that again will apply to people on the responsible governing body, as will the requirements around the suitability of key personnel, or rather what we will now call responsible persons. Now, we've just had a question in terms of the application to governing bodies, to local government. So yes, I will talk through that, because we've actually been giving a little bit of advice on this. And some of it does apply in strange ways, so I will talk about that. But this particular requirement, so in terms of who sits on your governing body, if you are a state or local government entity, you do not need to worry about any of this. Likewise, the Quality Care Advisory Body and Consumer Advisory Body, they don't apply to local government. So that's sort of some relief, I would say. But there is another tricky thing, which I'll talk about when it comes to responsible persons, that does apply to local government. And in my view, it doesn't make a lot of sense. I'm wondering whether it was intended to work this way, but there's a strange quirk in the legislation that effectively means that it will apply to local government but not state. So looking then at what these membership requirements are, it's really about having a board that has an independent majority. And what that means is they are people who are not employed by the organisation. So it's not your director of nursing, it's not your clinical care coordinator, it's not your CEO, it's not your finance team. And it's also not someone with an interest in the organisation. So what interest means kind of can be somewhat hard to work out in particular cases, but effectively the way the Commission will approach that is usually looking at where they've got a financial interest. So if you're a shareholder, you're not going to qualify as being independent. But let's just say you are a member of a church and you sit on the body of the provider associated with that church. That may not of itself mean that you're not going to be independent. It's just a question mark that goes that raises a question. It just puts a question mark. The other thing I just want to say, though, about this governing body is understanding what the governing body is. And the important thing to note about that there is that it is the board, and the board is anyone that's registered as an ASIC director. So this might sound a little bit circular, but likewise, to be on the board, you must be registered as an ASIC director, and all ASIC directors are by definition on the governing body. So sometimes we get the question from providers as to whether they can have a governing body that isn't registered with ASIC as directors, or they're not members under the associated under the Incorporated Associations Constitution, or they're not committee members or governing body members, whatever the particular terminology is. And the answer to that is no, you can't. In order to qualify as someone who's sitting on the governing body, you must be registered as an ASIC director. So I just wanted to make that point, because when these reforms came out, there was a lot of confusion about this concept, and including some materials distributed by the Aged Care Quality and Safety Commissioner, who put out sort of statements to the effect that you could have people who were on your governing body that weren't technically directors, and that's just not correct. And if it was, we would be happy with that. So we've certainly looked for it to be correct, but it's simply not. And they since withdrawn those statements. So there just has been a lot of confusion. So if any of you are in the situation where you are a company, whether it's proprietary limited or company limited by guarantee, your governing body does all have to be registered with ASIC. So then, in addition to who sits on the governing body, you also have to potentially have two advisory bodies. So the first is the Quality Care Advisory Body, and this is independent of the board. They give advice to the board. It may have board members on it. It should have a consumer representative on it, and it may have members of the clinical team and so forth on it as well. So that body must be established and must report to the board. The Consumer Advisory Body is something you need to give your consumers an opportunity to set up, and you need to do this at least once per year. Now, whether consumers actually set that up is a matter for them, but you do need to continually make the offer. And if you're getting no uptake from consumers to that, you need to really be looking for reasons why that might be, because the Commission isn't going to just accept, oh, we sent out a letter and we never heard anything, so we didn't do anything about it. They're going to be wanting you to think about, why aren't we getting uptake? Where are our consumers in the midst of all of this? So financial and prudential management. So moving on then from, and just to recap, this is the level 5, not local government and state government. When we're talking about financial and prudential management, we're talking anyone registered in level 4 and above, and that will be all providers. I have to double check whether it does apply to local and state government, and apologies, I can't recall off the top of my head for this one. But for the rest of you, you must have this financial and prudential management system. Now, if you've been previously operating in residential care, this looks a little bit like what used to be called a governance system, which was really prudential governance. Now it's broader than that, and it does also apply to those of you in a home care or community setting. So it's really a system that it's about ensuring your sustainability, ensuring you're managed in a financially sound manner, and making decisions that focus on the safety, health, wellbeing and quality of life of individuals accessing funded aged care services. In terms of what it needs to deal with, it needs to set out the roles, including the accountabilities and responsibilities of the staff who need to have a role in that financial governance, enable you to monitor and control any delegation or outsourcing of the roles and accountabilities or responsibilities. It needs to have internal reporting mechanisms and be able to detect and record and respond to any sort of non-compliance. In addition, going the wrong way. In terms of your ongoing obligations, once that system is established, you have to do regular training for the key staff so that they understand their roles and responsibilities. And at least once per year, you have to review your FPMS, as I'm calling it, because it's a bit of a mouthful, and think about what, if any, actions could be taken to improve the system. You need to do it regularly and at least once per financial year, but you also need to do it whenever there's some sort of change that might impact on the system or whenever you think, oh, the system is no longer compliant. But for most of you, that's going to be an annual thing. Okay, so we'll talk now about responsible person screening, because again, this is something that will be familiar to those of you who've been in home care or residential care. It's been around for the last couple of years, but definitely new for CHSP. So firstly, let's think about who responsible persons are. So these are anyone who sits on your governing body and anyone who is responsible for executive decisions of the provider, any person who has authority or responsibility for or significant influence over planning, directing or controlling the activities of the registered provider, any person who has responsibility for overall management of the nursing services delivered by the registered provider, and anyone who's responsible for day-to-day operations of a service delivery branch. Now, I will just make a note at this point, service delivery branch is not very clearly defined. So we're yet to understand exactly what that means. So for example, particularly in a home or community setting, it can be a little bit difficult to tell exactly what that means. So for example, does it mean the office of the council where the home care or CHSP services are run from, or could it include someone who you may have a staff member who runs day respite service somewhere? Is that the service delivery branch? So we don't really know yet. So it's a bit of a watch this space. But certainly anyone you consider to be in a bit of a management position at the front line, they may well constitute responsible person. I will also, though, make the point here, and I'm not going to go into this too much in this presentation, but that those number 3 and 4, they're not subject to the statutory duties, which is the obligation to take steps to protect those who you care for from harm. So I know there was a lot of feedback given when the exposure draft of the Act came out about how unfair it was to expose people who may not be very senior staff to potential civil or criminal penalties as they then were. And effectively, one of the things the government did was they excluded these two people from the statutory duty. So it really is only those more senior people, so anyone at that more executive or board level. Now, the other point I want to make to those of you in local government is that on our interpretation of the legislation, the councillors will constitute responsible persons. And so what that means is that you will need to do the screening requirements I'm going to talk about for those responsible persons. And they will also need to be aware of and comply with, say, the code of conduct. They need to be aware of the statement of rights and some other things I'll discuss through the presentation today. So while we don't need to worry about, having an independent majority and so forth on the council, that doesn't mean you don't have to worry about any of this at all. And certainly we think councillors do constitute responsible persons. So you're going to need to go through this screening for them. And it seems a little bit bizarre given the provider can't necessarily control who gets elected to council. So I'll just say I'd like to make it the point that it doesn't make a lot of sense to me. And I do wonder if maybe there'll be some reform at some point around this, because it does seem a little bit impractical. But on a plain reading of the Act, it doesn't seem that there's any way around this, that it does apply. So these are the obligations of the responsible persons themselves. This won't apply. There's additional obligations in residential care, but just to recap, notify the registered provider of a change of circumstances relating to a suitability matter. So that's what I'm going to talk about. Comply with the code of conduct. Again, I'll talk about that. Ensure the registered providers complies with their statutory duty. So again, this will only apply to those more senior responsible persons. So I think we've just had a comment. So let's have a look. Very good. Thank you. We've just had a comment very helpfully pointing out that financial and prudential management, you don't have to worry about if you're in local government or state government. So that's very helpful. Thank you. Okay, so in terms of suitability matters, so I'm going to look at it firstly from the perspective of the registered provider. So what it means is that you as a registered provider must assess the suitability of each of your responsible persons, which is why I've taken you through the definition so you know who you need to do this for. So you need to do this when they've commenced with you and every 12 months, and if there's some change. So I'll come to that. But in terms of what the suitability matters are, I've listed them here. There's more detail in the legislation as to exactly what these things are, but they're all fairly straightforward things, indictable offences, civil penalty, if they're bankrupt, have they been subject of an adverse finding by, for example, APRA or say ASIC, have they been found liable for fraud, misrepresentation or dishonesty? Has there been a banning order? That would obviously be extremely relevant. And have they been disqualified from managing corporations by your ASICs of the world? Now, the other one and probably the one that's trickiest in practice is this one here. So do they have experience in the provision of aged care? This is the one that we've seen become most contentious when, for example, a provider, say NDIS provider, applies to be registered as an approved provider to provide home care services. We often see the Commission criticising the responsible persons, criticising the application, I should say, because the responsible persons don't have enough experience in the provision of aged care. So this is the trickiest to establish hurdle. So what that means in practice is that when you're considering someone's suitability to be involved in to be a responsible person, you should give some thought to how you evidence and demonstrate this. So don't just say they're experienced, tick. You'd be wanting to give some more consideration to that, because if the Commission asks to see the record of your suitability assessment for that person and you don't have enough reasoning in there, they may find that that person is not suitable, and also find that you as the provider have not conducted your suitability assessment in an adequate way. So hopefully most of these things are going to be no, 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 no. And this one is a yes, but you can sort of discuss a bit why you say whatever experience they've got is relevant. It doesn't mean they have to have direct experience in the delivery of aged care, but you'd be wanting, if they came from a different industries, let's just say hospitality, and they're coming in to be, I don't know, your someone in charge of, say, quality, you'd be wanting to just demonstrate and think about how it is that experience translates across. Likewise, even if they worked in, say, health or disability, you'd still want some discussion as to how the experience they bring is relevant to provision of aged care, because it's not just an automatic tick. And we've seen the AAT grapple with this issue when it comes to NDIS providers applying to be registered as aged care providers. And where they've sort of found issue is you can't just say, well, I've done NDIS, therefore I can do aged care. You need to show familiarity with the aged care system specifically. So that doesn't necessarily need to be that I've worked in aged care, but you'd be wanting to show that that person has got relevant experience and that they have enough understanding of aged care to be considered suitable. The other point I'd just like to make here too is that it's not like if they say they have been bankrupt or they have been guilty of an offence, it doesn't mean they're automatically not suitable. It's just a relevant consideration. So it's about weighing all of these things up to determine if they're suitable. So don't think just because they were bankrupt 10 years ago, they can never be responsible persons. That's obviously not going to make them forever unsuitable. So now when it comes to these assessments, you have to consider the suitability of individuals, as I said, at the outset of when they commence, and then you have to report it to the Commissioner that you've found them to be suitable. So that's when they first become a responsible person. Again, if they cease to be a responsible person, you have to make a notification to the Commission then. Then the other situation which you need to notify the Commissioner is if there is some change in the suitability of persons. So this is, have they for example, let's just say they were charged with an offence or found guilty of an offence, or APRA has made a disciplinary finding against them. That responsible person has to notify you as the registered provider, and if they fail to do so, that's actually an offence on their part. They have 14 days to do that, and then you as the approved provider or associate registered provider, you then have a further 14 days to report that to the Commission and say whether or not they're still suitable. Now, if they are not suitable, you have to also tell the Commission what you're going to do about it. Effectively, you'd have to be trying to move them to a role where they're no longer responsible persons. And again, this is where these provisions don't make a lot of sense in my mind as to how they apply to local government, because what can you actually do if, say, one of your councillors, and I would say I'm not an expert in local government per se, but I would have thought having a conviction for an offence doesn't necessarily make someone automatically ineligible to be on council. So I don't really understand how it is you would be expected to manage this. So I think this may just be a bit of a watch this space, and we may see the Commission giving some more guidance on this at some point. So we'll move on from responsible persons now directly, although this, of course, is relevant to responsible persons as it is for all your workers. So in terms of the Code of Conduct, this is the code itself. To those of you who work in the NDIS space, this will look very familiar to you. Again, the Code of Conduct has been around for some time, but it's most relevantly for, of course, residential and home care. So this will be the first time it applies directly to CHSP. At a high level, the code all looks pretty straightforward, but I will just stress that the Commission has issued guidance on the Code of Conduct, and that comes in different levels. It has guidance for registered providers or approved providers, and it also has guidance for workers. So the thing I want to stress about that is that the guidance is about 60 pages. So the Commission's interpretation of what this means amounts to 60 pages. So the point I'm making there is that the Commission has some fairly strict interpretations of what the Code of Conduct is about, and certainly it's some things you wouldn't necessarily jump out at you as you wouldn't necessarily think, oh yes, that makes sense. So it's worth, if you are a responsible person in particular, it's worth having a look at that guidance. And as a registered provider, you should be making sure that the provider, that your responsible persons are aware of not only the code, but also the guidance. Likewise, workers. We heard from another source that a stat dec from the responsible person would be okay to deem some of these suitability matters. Is this true? That may be one way of evidencing the requirement. So the Act doesn't talk about how you go about evidencing it. Certainly a stat dec could be some evidence, but I think you should be also conducting your own searches to the extent you can. So let's just take the insolvency or bankruptcy. That's something you can do a search on pretty easily. Likewise, police checks. These are the sorts of things you can do quite easily. If they are a registered health practitioner, again, you can search the APRA register quite easily. So I wouldn't entirely rely on a stat dec in response to the question, is the answer to that. And then someone else has just asked another question. As councillors are elected officials, are we assuming that they don't need to meet this criteria? And the answer to that is unfortunately no. And again, I just stress it doesn't make a lot of sense to me, but on a plain reading of the legislation, they are still responsible persons, and therefore you as the registered provider do need to go through the suitability assessments for them. There's no exemption to that under the Act. So again, doesn't necessarily make a lot of sense, but that is what it is under the current legislation. So unless they do amend this, and perhaps the government will amend it at some point, I think that all of the responsible person screening will apply to councillors. So then just going back to the Code of Conduct. So that's the code itself. Just stressing again, there are guidelines, or the Commission's guidelines regarding the code of conduct, and you really do need to have a look at them as the registered provider and make sure your staff are aware of them. So, registered provider, you as a registered provider must comply with the applicable provisions of the code and ensure you have systems in place. For example, have policies that are about compliance with the code, have code of conduct training and policies. Make sure your associated provider contracts mention the code of conduct. That's something we will always put in our associated provider contracts, that the contractor has to make sure their staff are aware of and trained in the code. Now, we do sometimes suggest registered providers will give information to their associated providers to help them with that, but it certainly needs to go in the contract. You as a registered provider must also take reasonable steps to ensure that aged care workers and governing persons comply with the code, giving them a copy, providing them with the Commission's guidance, providing training and professional development, ensure if there's an understanding of what happens if the people fail to comply with the code, and help your staff and responsible persons understand and are supported to resolve issues regarding compliance with the code. So if you fail to comply with the code, there are possible sanctions and civil penalties available for the registered provider. Likewise, responsible persons, again, they must comply with the code, and that will include, as we said, counsellors. And there should be oversight of the code. So governing persons need to understand their obligations under the code, as well as that of the workers and the approved provider or registered provider's responsibility. Again, aged care workers have their own obligations to comply with the code. And the reason I want to stress this is because when it comes to the Commission and how they regulate the sector, if something goes wrong and a person receives poor care, typically the Commission they'll take action against the provider through the various regulatory compliance pathways. So non-compliance notices, perhaps sanctions, immediate severe risk findings. At worst, they can revoke approved provider status or registered provider status, or they could refuse to renew your registration under the new Act. So that's typically the way they go about regulating the providers. Now, but when we're talking about individual workers, the only way the Commission can regulate them is through the code. So what we see when something goes wrong and there's a particular worker who's done something inappropriate in some way, is the Commission may take action against that worker and actually end up banning them or perhaps disqualifying them from working in the industry for a period on the basis that they've breached the code. So the code is the way the Commission goes after individuals as opposed to the organisations in the sector. So we have seen the Commission ban quite a lot of people ever since the code has been out. I think I'm not 100% sure on the numbers, but I know within a few months it was already dozens. So you should, of course, be checking that register regularly just to make sure that you're not inadvertently employing someone who's under a banning order, or that your subcontractors aren't using someone under a banning order, because they can't, you shouldn't be subcontracting to anyone who's under one of these banning orders. But the point is that workers do need to take this seriously, and that if they do breach the code, particularly in those more serious or egregious breaches, they need to understand that they could face a banning order. Okay, so I thought I'll talk now a bit of a sidestep. We might get over to talking about agreements. Before I do, though, if anyone has any other questions about the governance side of things, code of conduct, responsible persons, or boards, feel free to keep popping them in the chat box. But otherwise, we'll move on and talk about agreements, because as we all know, these have been somewhat of a source of contention and concern among the industry. Now, the first point I'd like to just make here is that service agreements are required under the legislation. I know that there has been a rumour or perhaps some statement at some point by the department that the CHSP providers didn't need to worry about this for 12 months. I cannot see any legal basis for that statement, and I haven't seen it in writing, which makes me nervous that in other words, I wouldn't be relying on that as a provider. I think while there may be some leeway or discretion in terms of how much the commission's going to crack down on someone who doesn't have a valid service agreement in place with their consumers, I certainly think you should be aiming to have service agreements in place before or by 1 November, both for existing consumers if possible, and I do understand there are challenges with that, but certainly for any new consumers coming on from 1 November, I think you should be aiming to have a good agreement in place. Sorry about that. The reason I say that is, firstly, it's a condition of registration that you have a service agreement. So if you fail to comply with your conditions of registration, there's a range of things, sort of consequences of that, including all of the sanctions and so forth. But secondly, it's arguably a condition of funding. So while at the moment CHSP is funded pursuant to a grant agreement, you could, at worst, if you didn't have a compliant service agreement in place with your consumers by 1 November or on 1 November onwards, there could be a contention that you can't then claim funding. So I think it's very, very unlikely that any of the regulators or department would be inclined to push that, but just be aware that it's a risk. In terms of the requirements of the service agreements themselves, they are contained in the draft rules. So again, draft. We're going by draft rules only at the moment, but they are fairly lengthy. So just to give you an idea, there's a couple of the pages of the legislation, and that's actually not all of them. They go for another page and a bit. It's fairly detailed in terms of the information you put in there. The other thing, though, is that some of the provisions in there don't really make a lot of sense when it comes to CHSP. So, for example, there's a requirement that you put in your service contribution amounts. Makes perfect sense. That's fine. But then it also talks about needing to put in the price. It doesn't make sense to me that you would put in a price for CHSP services into a client agreement, given that the price has no real relevance for the client. So again, I wonder if some of these draft things might just be ironed out a little bit with the final draft of the legislation, but just to raise that, not all of it seems to be well designed for CHSP as opposed to, say, support at home. There are some other things in the service agreement requirements too that we're keeping our eye on. So the first one is that you must, quote, review your service agreement annually with each consumer and whenever the individual requests it. Now, what this actually means is really not stated and very unclear. So does it simply mean that you must look at the services you're providing with the client once a year and think about whether they're the appropriate services and so forth? Or does it mean you need to review your pricing every time the client asks for it? We simply don't know the answer to that at the moment. And to me, it doesn't make a lot of sense in a context where, by definition, you already have to review care plans regularly. So why would you then need to go back and review the service agreement as well? I'm not really sure how that's going to play out. So that's one part we're watching. Another thing just to be aware of is that, consistent with the Act's focus, or rather increased emphasis on using associated providers or contractors, if you're intending an associated provider or contractor to deliver a service, you must say so in the agreement. Now, this doesn't mean that a situation where you provide services in-house normally, but sometimes you have to outsource to an agency because someone's sick. That's not what it's talking about here, but certainly if you always contract out physio or gardening or whatever service, or home maintenance, for example, you should be saying that in the service agreement at the outset. And I think that's really just intended to make it clear to clients at the outset when they sign up to you that you will not be the service provider necessarily. So just another new provision in there. This just gives you a little bit of an idea of how we're dealing with some of it in our client agreements or CHSP agreements. So you're putting in some of the, the services here, the contributions, how the contributions are paid and calculated, how they physically pay, can they pay by direct debit? And to those of you who are wondering, it's absolutely fine to mandate direct debit. I know some providers have clients who prefer to pay by other methods, or whether it's cash or check or whatever it might be, although I think checks are going. the answer is you are 100% allowed to mandate how clients pay. You don't have to facilitate every sort of payment method. And then just a provision here that talks about how you'll increase client contributions. So you are allowed to increase client contributions, but you need to say so in the agreement. So in addition to the agreement itself, you have to provide information to new and prospective clients. And this can be done either in the agreement or separately to it. And there's pros and cons to each approach, which I'll talk about. But just in terms of the information you need to provide, information about the statement of rights, information that helps them choose the funded aged care service that best meets their need. So this is really about, do they choose CHSP or do they choose support at home if they're approved for both? You have to give them information about your complaints and feedback and policies and whistleblower policies. And again, I'll talk a little bit about that. You have to give them information about the privacy provisions in the Aged Care Act. And again, I'll talk a little bit more about that. And code of conduct, means testing. This is not relevant for CHSP now, but obviously will become so. How you cease delivering security of tenure, really, and information about how they can be involved in their care planning, as well as monthly statements. So, as I said, there's two ways you can go about providing this information. The first way is to do it in the agreement, and that's really the approach that we've taken in our client agreements in general. I've just put a copy of the index here. For the main reason being, firstly, I'll say, so that's one approach. You could also do it verbally. You could also do it by way of a handbook. Now, there is an appeal to doing it verbally in that it's less written information you have to give to clients. And I know that the department, I believe, is developing some sort of a checklist that talks about the information that you need to give to consumers. I think it's even in the home support at home manual. There's a checklist in there about all the information you need to give to consumers. So you could have staff talk through the information that way. My concern with with conveying the information verbally is that it's a lot to put on your staff to explain what may be quite complex concepts to them, and certainly getting them to then document that is going to be hard. So I think it's much, much, much safer to do it in writing, whether it's in the agreement or otherwise. Now, again, there's some pros and cons to doing it in the agreement or in a handbook or some sort of fact sheets or something. And those are as follows. So if we put it in the agreement, you know that it's going to all be given to the consumer at once. So it's quite easy, in a sense, to evidence that you gave the consumer everything you had to. If you put it in a separate document, that's absolutely fine, provided you've got good records of what you gave the consumer and which version. Because sometimes what we see when providers do rely on information sheets or perhaps sort of handbooks and things like that is that down the track, someone says, oh, I wasn't told about your price increases, let's just say. And we ask the provider, well, what did you tell them about price increases? And they don't have a record of exactly what was given at the time. So totally fine. And I can certainly see the appeal in stripping some of the information out of the agreement, put it into a separate document. And that appeal is that it keeps the agreement much shorter, but just be aware there's some pros and cons either way. One thing you could think about if you would prefer to do that sort of system is have the client actually acknowledge receipt of the fact sheets and just keep good records of exactly the versions of the fact sheets you gave them. Okay, incident management and SIRS. So I'll talk again. This is something that has been around in residential care and home care now for a few years, but again, it's new to CHSP. And just to recap, incident management obligations only apply if you're level 2 and above. So that'll be most providers, but not all. SIRS applies to everyone. So this is really relevant information to understand. So SIRS are effectively allegations or incidents. And I will stress that it doesn't matter how well founded the allegation is, even if you know something to be completely untrue, you are still required to make a SIRS report if it falls within the definition that I'll talk through. So quite often we see situations where a family member makes a complaint, let's just say, and says, I'm really unhappy that my mother wasn't sent to hospital earlier. And your staff say, oh, well, the reason she wasn't sent to hospital is because we had a discussion with her and her GP, and it was decided she didn't need to go to hospital at that time. Now, so that you go back and resolve the complaint that way. However, what the family member alleged was neglect. So the fact that it wasn't actually neglect doesn't mean it's not a SIRS. So you still need to make a SIRS report in that scenario. And it sounds a bit strange. And there are even more ridiculous examples that I could give you, such as someone, let's just say they say, oh, I brought a balloon over for mum last week and it's gone, and the staff member says, oh yeah, well, it was flat, so your mum asked me to put it in the bin, to pop it and put it in the bin. But if the family member said the balloon was stolen, well, that's an allegation of theft. So that is a SIRS. And again, really ridiculous. You know it's not true. There's a perfectly logical explanation, but the fact that it's been alleged means you do have to treat it as a SIRS. So it's just really, you do need to have a really good understanding of what could constitute an allegation versus an incident. And of course, make sure you report. And you're in some ways better to over-report, although I will sort of stress you do need to be careful about how you go about reporting. Okay, so it's only though for things that happen in the connection with the provision of funded aged care, and that's obviously particularly relevant for a supported home or CHSP environment, where not everything that goes wrong for a particular consumer is going to relate to the care you're delivering. So let's just say that a consumer calls and reports that they had a fall, and it was outside the time when they were in your service or anyone was attending to them. That's probably not in connection with the provision of funded care. However, let's just imagine the same thing, but they say, I fell over the hose that the gardener, CHSP funded gardener, left out. That obviously would be in connection with the provision of funded care. Likewise, staff attend someone's home on a given day to provide some sort of service, and they find the care recipient lying on the floor. Perhaps that incident has not occurred in connection with the delivery of care, but you might be best to report it because they were there when they found the person. I would say that probably isn't, but I've seen situations where the Commission's taken the view that actually that is in connection, so you should report it. Now, looking at the types of allegations or incidents that get reported. So unreasonable use of force. This is, the care recipient saying so-and-so was rough with me or so-and-so hit me. All of those, whether it's violent or really just rough, that will get caught. Unlawful sexual contact or inappropriate sexual conduct, again, that's by a staff member, of course, that will be reportable. Psychological or emotional abuse, that's by a staff member or other care recipients. Unexpected death, stealing or financial coercion by a staff member, and I just stress their staff member because we do sometimes get asked about family and family aren't caught. Neglect, again, by the provider. Unexplained absence from care. So this may not be where someone attends and the care recipient isn't at home. Maybe it would be, and they should be. It would certainly cover if the care recipient was out shopping with a carer and they wandered off. So that would definitely be covered. Inappropriate use of restrictive practices. So as I said earlier, restrictive practices, the rules, the conditions don't apply to supported home or CHSP, but we do see them come in this sort of sneaky back door to CHSP and home support. And really what that means is if it's not authorised by the care plan, then this would potentially be reportable. So let's just say a care recipient tried to wander off and the staff member restrained them from doing so, and there was no authorisation for that. That would be an unauthorised use of the restrictive practice and therefore reportable. So just to reiterate, remember allegations, even if they're clearly untrue, are reportable. Be careful not to miss allegations. For example, if there's a complaint, sometimes the Commission might say you don't need to report the allegation. Let's just say they know that this particular care recipient repeatedly makes allegations that are unfounded, perhaps due to some trauma, and they've got a cognitive impairment, and they repeatedly say that someone strange is wandering into their house or something like that. The Commission might exercise its discretion to say you don't need to keep reporting this to us, but it's for them to do, not for you to go, oh, well, it's clearly untrue, we don't need to worry about reporting it. Priority one is really any incident which could have caused or could reasonably have been expected to have caused a client physical or psychological injury or discomfort that requires treatment, or where there are reasonable grounds to report the incident to police. What the difference between priority one and priority two means is that you have 30 days to report a priority two, whereas priority one, you only have 24 hours. So you need to be able to spot priority ones pretty quickly and make sure you report them. Now, it's only when the provider becomes aware, so particularly in a support at home or community environment, if you have contracted staff out there on the weekend, if something happens on a Saturday, they tell you on the Monday, your 24 hours will start then. But I would stress that doesn't mean you should not make sure your contractors are telling you things quick, because even if you have 24 hours to report, your incident management obligations may kick in earlier than that. So you can't just sort of not worry about it until you hear about it. You do need to still be overseeing, make sure you've got an incident management system that can respond appropriately and you don't find something out a week after it's happened. Okay, so SIRS is only part of your responsibility. So looking more broadly, as an organisation, you have an obligation to have an incident management system that's broader than just SIRS, so just those 8 sort of categories. So these are any incidents that occur or are alleged to have occurred or suspected to have occurred in connection with the delivery of funded aged care, and that either have caused or could have caused harm to any person. Now, just be aware there that it's any person. So that will include staff. It will include other family members that might be in attendance at a person's home. It may include members of the public that are, using the hall at the same time as you're running an event. So basically, it's really just about having a good risk management and incident management system. If the person injured was, let's just say, nothing to do with your care recipients, let's just say it's a staff member, that may have obligations in terms of WorkSafe, but it's probably not something that's going to be a SIRS, but it should still be dealt with as an incident. And we have had issues where, say, a provider has been criticised because they haven't dealt with an incident where a staff member was harmed under their incident management system under the Aged Care Act, because they think, oh, this is just a WorkSafe issue, we don't need to worry about this in terms of aged care. But actually, the Aged Care Commission has said, no, it's still an incident. We need to see it action through your incident management system. Now, you might have your sort of WorkSafe OH&S system over here, and that's fine. You just need to make sure it still feeds into your incident management system under the Aged Care Act. Now, when it comes to your incident management system too, you must provide training at least annually. And whenever someone becomes a worker or a responsible person, or there's some sort of change that affects the incident management requirements for them. Complaints and feedback. Although the Aged Care Act has had a requirement for you to have a complaints and feedback policy forever, as far as I can remember, the level of detail in the new Act is so much more extensive than it's ever been. It's gone from a couple of lines into pages and pages and pages of requirements. So whether or not you're CHSP or support at home, home care or residential care, this is new. So definitely worth being aware of. So the new Act has detailed provisions regarding complaints and feedback, and it requires that you have both a documented system and a policy. And the policy has to be given to clients, supporters, staff, and responsible persons, and they have to be reminded about it monthly. You also have an obligation to make sure your clients and supporters understand your policy. and you have to give it to anyone else who asks for it. So let's just say they may not be a representative, they may not be a supporter, but it's some family member of a client. Perhaps they ask you, they want to know how to make a complaint, you must give that information to them. But it also includes really any member of the public could technically make a complaint if they wanted to. How relevant and meritorious that would be is another question. You have to review your system at least annually, and you have to provide training to staff at least annually on your complaints and feedback system. Now, some people have asked me, okay, well, if I have a documented system, can't I just give that to clients? The answer to that is you can, but I think you're giving them far more information than they need. And I think you should have a separate policy that's a bit shorter and simpler. We've got templates of these, and just to give you an idea, our policy is our system or the procedure, the internal document's about 10-ish pages, whereas our policy is about 2. And the other reason I think is better to keep it separate is because the policy doesn't have to have the same level of detail as the system. And given that you have to give it to consumers and their supporters and help them understand it, it's better to keep it simpler and shorter and more to the point. Also, you do actually have an obligation to translate it for people with a CALD background who can't understand it in English. So, or potentially reformat it if it's, say, for those with a vision impairment. So keeping the policy as simple and short as possible is the better way to go, at least in my opinion. Now, whistleblower protections, these sit alongside the complaints system. And my colleague, Victor Harcourt, gave a presentation on whistleblowers last week. To those of you who may have seen it, but there's a lot of confusion about how these two things interact. And to be honest, it's very fair confusion because it doesn't make a lot of sense in my mind. But effectively, anything that's a complaint could also be a whistleblower disclosure and vice versa. Because unlike we see with other whistleblower laws, let's just take ASIC or the Corporations Act as an example, where only a select number of people can make a whistleblower disclosure. And if they want to make a whistleblower complaint, they have to do it to sort of certain people. So that's your official government authorities or potentially to someone senior in the organisation. But unfortunately for aged care, under the Aged Care Act, anybody at all can make a whistleblower disclosure, and they can make it to any member, anyone who's an aged care worker. And so that's not only your staff, your employees, but it's also your contracted workforce. So anyone who falls within that definition, they can receive a whistleblower disclosure. So that means it's going to be pretty important that you're able to spot what is a whistleblower disclosure. And it's a much lower threshold as well. So anything that's where the person has reasonable grounds to suspect there's been a breach of the Act can qualify as a whistleblower disclosure. Now, one might think breach of the Act, that sounds quite serious, but if we think about how that actually gets interpreted in practice, if you fail to deliver care in accordance with the person's wishes and preferences, let's just say on a given day you can't get their preferred staff member and you need to use someone else, potentially that person could say, well, that wasn't in accordance with my rights and my choice, therefore you've breached the Act. I don't necessarily know that I'd agree with that, but that's potentially a breach of the Act. And certainly when we see the aged care regulators interpreting this is how they sort of interpret it. So it really can capture complaints about almost anything. You know, the example in residential care, which could constitute is my meal was cold yesterday. That could be a whistleblower disclosure. So I think what this basically means is you really have to have a system that, whether it's a complaint or whistleblower disclosure, it comes in and you make sure it's well managed. You're not breaching confidentiality if the person wants you to keep it confidential, that you are and allowing, not taking any sort of, not victimizing them or taking any form of recrimination. So that might sound obvious, but sometimes we get providers who say, oh, this client is really difficult, we can't make them happy, let's just tell them we can't look after them anymore. Now, that's a breach of security of tenure for one thing, but that would also be a breach of their right to not be victimized or subject to recrimination. So this is a topic in itself. As I said, We're doing a lot of work around this at the moment, but suffice to say, it's going to require some getting used to. And don't just think of whistleblower disclosures as more serious things. It could be lower level complaints as well. As with complaints, you do need to regularly review your system and train staff on it. You also need to remind people about the right to make a whistleblower disclosure monthly or potentially more often. So as I said, review it annually, make sure it's current and best practice. This goes for both systems, and have a look at these sorts of documents. This is what the Commission says you should do when you're assessing your complaints and feedback policies. I've talked about publishing them, but again, as both for complaints and whistleblowers, I recommend a short document rather than providing your entire system to clients, just because it's going to be overwhelming. It's going to contain information that's not relevant, potentially information that they shouldn't have, and also will just be a bit overwhelming. Training has to be done annually. And these are just some of the things that the Commission says you should cover in that training. Security of tenure. So this will be familiar to any of you, particularly who've worked in residential care, as well as home care. It's new to CHSP, although I would say that I think that mostly CHSP providers have probably got systems that are fairly consistent with this anyway. So there are two things if you are looking to terminate services that you need to establish from a legal perspective. And again, draft rules, so this is all subject to change, but I think we should see this go through as is. There's not a lot of issues with it, in my opinion. So firstly, you have to have legitimate grounds or a good reason to terminate services, and I'll go into that a bit more. The second thing is you need to give notice, and what that means is at least 14 days notice. But what is not required is you do not need to find the client an alternative provider. And I stress this because there's a real misconception out there that this is the case. I've seen statements from the Commission suggesting this is the case, and there's just simply no basis for it. So let's just say you've got a recalcitrant non-payer, you've got someone who's regularly abusing your staff. You do not need to find them another provider to go through the pain on your behalf. You can just cease services. Now, I'm not saying you always would. There might be reasons, there might be duty of care issues to consider, but do not feel that you have to find the client a new provider in order to legitimately terminate services. It's simply not the case, and the law is pretty clear. It's very different to residential care in that respect, where effectively you can't terminate until they've got somewhere else to go. And I suspect the reason for that is, unlike residential care, that you terminating services doesn't mean they're getting kicked out of their home. So looking at the grounds, because this is the more challenging aspect of security of tenure. There are 5 grounds on which you can terminate tenure. The 5th is pretty straightforward. It's where they want to terminate or they move somewhere that you don't provide services. But numbers 1, 3, and 4 are probably the most relevant ones, or the ones we look at most frequently. So firstly, if the client can't be cared for within the community, within the resources available to the provider can terminate. Typically, this will arise where the consumer's care needs have increased. Let's just say they were originally receiving some low-level support services from you, and now they really need higher level services you don't provide, clinical care, or perhaps they really need to go to residential care. That can be a reason to terminate services, because you might make the assessment that it's not safe for us to keep coming in to provide this sort of low level of service, and we simply can't continue to do that. Number 2, if they no longer need the care that you provide, probably unlikely, or an aged care assessor assesses that actually they should be in residential care. That sort of ties in with 1. But again, if you've got an approved aged care assessor saying this person doesn't need the services that you provide, then that would be reason to terminate. Number 3 does come up a lot. Number 3 comes up a lot. So intentionally causing serious injury. Fortunately, that's pretty rare, but intentionally infringing the rights of an aged care worker to work in a safe environment. This comes up more often than we'd like. Now, that doesn't just mean they are creating a hazardous environment or being violent with your support workers. It could mean that they are regularly harassing people in your office and sending nasty emails or being really demanding with people in your office. Anything that you would think of that you wouldn't accept in your staff towards each other, that may constitute grounds to terminate on the basis that they have intentionally infringed the rights of an aged care worker to work in a safe environment. Now, where this does get tricky, in my experience, is where the person who is the problem is not the care recipient themselves, it's a family member. So let's just say that it's their daughter who is really giving staff a hard time and putting them down or making demeaning comments or criticising or harassing staff in the office. So then it's not really the client's fault, but I would just always explore whether in fact the client is in some way complicit, or are they allowing their daughter to do this? If the client's got capacity, you might be saying to the client, we can't actually keep servicing you while your daughter's around. You need to make sure she's not in attendance at the home, and we're only going to communicate with you moving forward. We're not going to communicate with your daughter. So it's not as straightforward, but generally it's not like it's as easy as, oh well, the client's fine, it's just their daughter. That means that that you don't have grounds to terminate. Not paying contribution, that's probably bit more of an easy one to spot. There is this requirement that it has to be for a reason within their control. And this is where if you're seeing a situation where a client is being financially abused, or let's just say they're suffering some kind of hardship, but their hardship hasn't been processed, you might not have grounds to terminate in that scenario. But in an environment which is means tested, and certainly CHSP is not government means assessed, as I understand, but you would go through your own assessment, there isn't really any reason why people can't pay their fees on an ongoing basis. If they can't pay their fees, there's got to be a reason, and usually it's some sort of financial misappropriation. So there are things that can be done, but that's also a ground on which you might look to terminate services. I would also say, though, the Act requires 14 days, but we always recommend sort of an escalation process for these. So it might be that first you send a warning letter saying if you don't cease, making inappropriate comments to our staff, then we may look to terminate, and then you might trigger it when it happens again. So it's not like you'll be jumping the gun on any of these things. They would be an escalation process involved, but just be aware of the grounds are there. And generally, if you're feeling there's some reason why services can't be provided, or they can't be provided safely, or the client isn't paying, these are the sorts of things you should be exploring. The other point I would just make about this is this all reflects very, very closely the current rules for termination in home care. So if you've been operating in the home care context, then this will all feel quite familiar. And it also goes, I think, to the fact that all of these have worked reasonably well, evidently, from a policy perspective. So I think that, providers don't routinely go and just cease services for no reason, in my experience. But what you can't terminate for, and this goes back to what I was previously talking about with the complaints and whistleblowers, is you can't terminate just because someone's complaining. If someone is complaining, they're doing it appropriately, they're not harassing staff, they're not making demeaning comments, then you can't terminate for that reason just because they've got unreasonable expectations. What you could terminate for is if they are being abusive in the way they're raising those complaints, if they are yelling at staff, if they are being unreasonable in terms of the expectations they have of you. But it's not as easy as saying, oh, we just can't make this person happy, we're going to terminate. So just wanted to make that point. Supporters, I think this probably ties in nicely with the last subject, but suffice to say, I just really want to make the point, because again, this is an area of the Act that changed a lot from the exposure draft, but supporters cannot make decisions, and supporters must be registered with the system governor. A supporter is not just someone who says, oh yes, I'm the supporter for the client. So they do have to be officially registered with the system governor. So when you're talking about supporters, or the Act is talking about supporters, there'll be a bit of paper that proves that person is in fact a supporter. And the other thing is that supporters can't make decisions. So everything they do should be with consent of the individual themselves, or if the individual is not capable, it needs to be with the consent of whoever their proper decision maker is, their legally appointed power of attorney, guardian, financial administrator, or whoever that might be. So as we can see here, this is a particular section of the Act. What the supporter is there to do is really act as a bit of a conduit of information so that they can receive information from you and convey it to the consumer, and likewise they can convey the consumer's wishes and preferences back to you. Now, where this gets a bit tricky is how do you know they are telling you what the client really wants, particularly if in, you know, a community environment where you may not necessarily have all that much face-to-face contact with the client. How do you know the supporter is in fact conveying what the client wants? So that's going to be something that's important to think about, because you can't just rely on someone saying, I'm a supporter, therefore you must do what I say. You do need to be continually touching base with the client to make sure that you are doing what is right by them, because the supporter has no legal decision-making authority. And we see it with powers of attorney, where families say, I'm the power of attorney, don't you dare talk to my mum about what's going on with her care. And my response to that is always, we absolutely have to talk to the mum to the extent she's able to understand the information, because we should always be respecting the person's right to be involved in their care. And it's completely inappropriate, both for the power of attorney, but also for the provider, to just exclude someone from the conversations. Sometimes this comes up, for example, when it comes to to debts, where a family member is not paying the fees, and I'll say to them, well, have you, the provider, spoken to the resident or client about this? And they'll say, oh no, they don't want to be involved in discussions about their fees or finances. And I would just say, well, they have to be. It's really important that they understand, because they're the ones whose, you know, tenure is threatened, or they may not be able to continue to receive services. And potentially they're also the ones who are being financially abused in some way. So it's really important with everything to continually involve the person themselves. Okay, so now record keeping, just before we wrap up for hopefully some more questions. And I've got a couple of slides on associated providers, but we'll see how we go for timing. So privacy and record keeping. Suffice to say, the new Act has quite a bit of emphasis on privacy and record keeping, which is new for the Aged Care Act, but fortunately not all that new for most of you, because it reflects a little bit what's already existing under various laws. So there is more emphasis on the need to protect personal information. So I think that's really in line with the sort of public concern around issues around data security and so forth. There's also obligations to protect personal information, not disclose it without consent. And again, I just want to reiterate here that just being a supporter doesn't mean they get to have, that a family member gets to have unfettered access to someone's information. You must only give information to supporters if the client consents, or the supporter has some sort of legal authority to the information beyond being a supporter. Also, the Act operates alongside other laws. So depending which state you're in, and not all of these apply to government, but if you are in the private sector, you'll be governed by the Privacy Act, Health Records Act, Health Records and Information Privacy Act in New South Wales. There's the Health Records Act in the ACT, NDIS laws and others, and there's also various laws that apply to the protection of personal information in the public sector as well. So the Act doesn't displace any of that, and you do have to sometimes grapple with how to reconcile the two. So under the New Aged Care Act, you now have to keep records for 7 years from the date that they were created. So it used to be 3 years, but it's going out to 7 years. And there are certain records that CHIS providers specifically have to keep, so just be aware of them. You have to keep records of all of your complaints and feedback, responses and improvements made, incidents. It's basically everything that you need to demonstrate compliance with the Act. So you're going to be keeping a lot of information. Now, keeping information doesn't mean keeping it in hard copy. It's perfectly fine to keep it in electronic form. And the other point to make is that while the provision has been extended to 7 years, This still operates alongside those state laws, and Victoria, New South Wales and the ACT require you to retain records for 7 years after the client has stopped receiving services from you. So that may actually be longer than the 7-year period. It probably will be longer for most clients. So in this scenario where you've got two potentially conflicting periods, you go with the longer one. Is the way I would approach that. It's not overly helpful that we have to try and grapple with these things. And for those of you who operate in multiple states, you have to sort of work out a policy that works across the board. What we tend to suggest in that scenario is you take the longer period and use that as your base, but there's obviously risks with that. So you do want to have good data security. So if you haven't already, now's probably a good time to have a look at your record retention policy. Okay, so when will Russell Kennedy have client and associated provider agreements for support at home ready to go, please? We understand they are currently in draft. Yes, they are in draft, but I have some good news in that what we're doing currently is we're updating all of our associated provider agreements. We have about 4, just so you know. We're updating them so that they not only reflect the current Act, but that will carry you over to the new Act. Now, they are literally getting their final tweaks made to date. So they will be available on our RK Docs Connect website by the end of the week, hopefully actually before that, but I will say confidently by the end of the week. We've got our associated provider, our standard home care support, CHSP associated provider agreement up there already. So that's already available for purchase, but there are some other ones going up as well. And I'll also just say that if you do purchase a Russell Kennedy agreement, basically what we're doing is we will give you updates through till 30th of June 2026. So you don't need to worry about getting an updated version when the new Act comes. We will give you a version that works now and a version that works when the new Act comes, and you'll keep going through till 30 June next year. Okay, these need to be in hard copies, or can we provide links to this info online? So this is, I think, talking about, and please let me know if I'm wrong, but I think we're talking here about the whistleblower policy and complaints policies. Links, I would be a little bit nervous with providing them as links only. I think at least the first time you give them to clients, you should be giving them a hard copy, an electronic copy, I think would be okay. So let's just say you distribute your client agreements electronically, and that's certainly fine. I think you would want certainly a copy in the PDF. A link might suffice, but I guess it's just a bit of a question. And the commission might say, and someone says, well, I couldn't access the link, or the link was broken. How are you going to really prove that you gave it to them? I would just be a little bit nervous about that. But I think in terms of the monthly obligation to remind people that they can make a complaint or whistleblower, I think links are perfectly fine for that. A complaints brochure is not sufficient. A complaints brochure might be sufficient provided it meets all the requirements for what your complaints brochure, complaint system or policy needs to say. So it probably is sufficient, but you would just need to make sure it ticks all of the boxes. The legislation about complaints and whistleblowers is in chapter, I think it's 3 of the rules, but certainly they'll be in the final rules. So just make sure you go through that, make sure you've addressed each of the criteria in there. Will Russell Kennedy do a webinar specifically on whistleblowers? We actually did do one last week, and certainly we're happy to rerun that again as well. And it's something I have presented on through some of these webinars before, but certainly we'd be happy to do more webinars, and things are evolving. So I think that this is an area, I think the whistleblowers is perhaps the biggest unknown aspect of the new Aged Care Act in some ways from a legal perspective. I think we've got a lot to come there. So I think it's something you definitely want to keep an eye on and stay in contact with organisations like ours and your SSD network to make sure you're getting new information, because it's something that's very new, not only for the sector, but also for the government authorities who also have to triage things to work out if they're whistleblowers or complaints and deal with them. So I think that there will be a lot of information to come there. So definitely one to watch out for, more resources. We do have the template documents again on our website. So if the client doesn't have capacity to mention behaviours as such as infringing the right to work in a safe environment, but not intentionally, is this grounds? Great question. And the answer to that is Potentially. Remember that ground that's about whether or not you can care for the care recipient within the resources available to you. That might be where that sort of behaviour becomes relevant. It's not so much that they're intentionally making someone unsafe, but perhaps you don't have the resources to care for them in a home-based environment if their behaviours are so extreme that they, you can't resource the services. So it's not necessarily the same way you would approach someone who was abusing staff more intentionally, but you might still have grounds. But again, it's just something you'd need to explore. Okay, just seeing, do we need to provide clients with the definition of high quality care? The answer to that is no, not to my knowledge, at least. Who knows, the Commission or Department may take a particular view on these sorts of things and sometimes do, but there's no obligation in the Act to do so, no. So that's a sort of, I think, a bit of a win for the sector, because certainly I have to say, quite shocked at what is involved in the definition of high quality care when it's sort of this long. It's certainly not something that's easy to demonstrate. So, yeah, not something you need to concern yourselves with at this stage. There's enough information that you need to give to clients, if we go back to that slide with the 10 or so items, without worrying about telling them what high quality care means. So could change, but fortunately at the moment. So just to wrap up, in terms of what I would sort of say you probably need to be looking for from a document perspective is having, or document or sort of systems perspective, having your governance structure in place, making sure you've got the right people sitting on your board or governing body unless you're in government. Systems to help responsible persons exercise their due diligence. So this is part of that statutory duty, which I didn't talk very much about today. Financial and prudential management system for those of you, again, non-government and who are subject to that, so level 4 and above. You need to have responsible persons assessment tools. You need to have a CHSP agreement. You need to have associated provider agreements. CHSP client agreement is what I really mean by number 5. You need to have complaints and feedback systems and policies, whistleblower systems and policies, and an incident management system, which also includes SIRS. So a lot of this stuff we do have templates for. There's other templates out there that can be purchased as well. So there's, a range of resources available to you. If you have any questions and need help with any of the above, obviously, please do reach out. We're here to help, and we've certainly put a lot of work into all our templates to hopefully make them as user-friendly and accessible as possible.